Law Easily. Author Dr. Ronald Ebert. Concept Dr. Ronald Ebert. And voice also me, Dr. Ronald Ebert. European law in a broad sense, the European Convention on Human Rights, ACHR, the law of the European Union, EU law, today EU law. Can airlines be obliged to carry checked-in luggage without surcharge? Judgment by the Court of Justice of the European Union, ECJ, Vueling Airlines SA versus Instituto Galego de Consumo de la Junta de Galicia, excuse my bad Spanish, case 387 from 12 September 14, 2014. A Spanish lady bought 4 return plane tickets from La Coruña to Amsterdam for the price of €240. The airline added €40 extra for the checking in of 2 pieces of baggage online. The lady launched a complaint on the grounds that the rule for this surcharge was an unfair term. The Consumer Protection Institution of the Autonomous Community of Galicia imposed an administrative penalty of €3,000 against the airline. The airline turned to the competent administrative court against this penalty. The administrative court had doubts whether the Spanish law forbidding such extra charges was in line with European law. Therefore, the court turned to the Court of Justice of the European Union, ECJ, with a preliminary ruling asking a concrete question concerning the interpretation of the relevant EU law. The Court of Justice of the European Union interpreted the Regulation on Common Rules for the Operation of Air Services, Regulation 1008 from 2008, and the court found that the price to be paid for the carriage of baggage checked in by air passengers is not an unavoidable and foreseeable item of the air service, but may be, within the meaning of EU law, an optional supplement in respect of a complementary service. What does this mean? In other words, surcharge for checked-in baggage by airlines is not against European law and cannot be forbidden by the national lawgiver, whereas hand baggage is a necessary item for the carriage of passengers and cannot be a subject of a price supplement as long as it meets the reasonable requirements concerning its weight, size, and security provisions. With this preliminary ruling, a national court has again managed to clarify an important question by turning to the court in Luxembourg, even if the result is not convenient for the consumer. Let's hope there's going to be more and more diligent judges to put questions to Luxembourg to the benefit of the citizens of the EU. Remember that the normal EU citizens would not be able to turn to the Court of Justice of the European Union. We need the national judges for this. Would you like to get learning stimuli for European law without any costs and risks? Then please click on the link under this video.